Ask parents, attorneys, or even judges about family court outcomes, and you will hear a rare consensus. The results are consistently poor. When an institution reliably produces results that everyone dislikes, the natural human response is frustration. The prevailing narrative becomes a simple grievance. The system is broken. But treating these outcomes as the byproduct of a broken system is an analytical error. It leaves us searching for bad actors to blame, rather than mechanisms to fix. Family courts produce these results because they operate according to their design. It is a processing engine running on fixed rules to generate predictable outputs. Every ruling is a product of this architecture. To understand the harm, we must reverse engineer the rules governing the machine. Looking closely at this architecture, we find 5 specific policy designs that make poor outcomes inevitable. As long as we treat these predictable outputs as isolated individual failures, the actual rules dictating the results remain invisible and untouched. The first question we have to ask of any mechanical process is what it optimizes for. Family courts are under immense docket pressure. Because of this volume, the structural optimization target is case throughput and finality. Judicial performance is measured by cases closed, not by longitudinal child well-being. When the primary performance metric is clearing the docket, rushed custody orders are the rational output of the system. This demand for speed directly dictates the information the decision-maker is allowed to process. This creates a severe input constraint, the snapshot problem. Judges must rule based on a brief, isolated hearing. By limiting inputs to a single point in time, the architecture excludes pattern evidence. Months of documented escalation and boundary violations are structurally deflected. A protective parent may have months of careful documentation, but no mechanism to input it. Meanwhile, a dangerous parent only needs to perform well for 15 minutes in a courtroom. The system optimizes for speed by blinding itself to longitudinal context. It makes decisions based on highly incomplete data, structured to look complete. When a system makes decisions using artificially constrained data, it will make errors. We then have to ask who bears the cost of those mistakes. This is an error cost allocation problem. If a judge grants access to an abusive parent, the institution faces zero consequence. The entire cost falls on the child. Because institutions internalize the risk of overprotecting, decision-makers gravitate toward risk-averse rulings. They default to equal, not safe. This aversion to risk dictates the behavioral pathways the system rewards. The architecture structurally conflates compliance with safety. It heavily favors the parent who appears cooperative, completely separate from whether that cooperation actually keeps a child safe. This creates a dangerous trap. If a parent attempts to introduce documented safety concerns, the algorithm processes that friction as a negative input, automatically flagging them as high conflict. High conflict is a label with no clinical definition, yet it carries immense legal weight. It actively penalizes advocacy for a child's protection and rewards coerced silence. An infrastructure that forces children to absorb the cost of its errors while punishing parents who try to supply warning data is engineered to minimize institutional friction. It is not engineered to protect the vulnerable. All of these flaws point to a fifth, macro-level design question. Where are the feedback loops in this architecture? They do not exist. There is a staggering blind spot at the core of the family court system. No state systematically tracks post-order outcomes. Once a custody order is issued, the system has no built-in mechanism to determine if that ruling resulted in stability, safety, or severe harm. A processing engine without a feedback loop is incapable of learning. It generates thousands of outputs without ever measuring a single result. The criminal justice system tracks recidivism and reentry data to gauge effectiveness. Family courts lack even this basic data science. Bad defaults, critical information gaps, and misaligned incentives continue indefinitely because the system lacks the basic sensory organs required to detect its own failure at scale. If the missing feedback loop is the core architectural failure, the specific engineering solution is mandatory outcome tracking. Re-engineering this system requires moving past anecdotal arguments and into longitudinal data. We need to measure what actually happens to a child months or years after a judge signs an order. We need specific, measurable indicators of system health. The Family Court Metric Catalog organizes 72 data points, from post-order modification rates to ignored safety concerns, into a single accountability framework. These metrics provide quantitative comparisons between jurisdictions, revealing where the snapshot problem and compliance trap distort outcomes. Tools like CoTrackPro's documentation model provide the raw, structured evidence needed to feed this catalog, giving court administrators the longitudinal view that single hearings structurally exclude. Measuring outcomes is a matter of institutional competence. It replaces ideology with anonymized, aggregate pattern data. This data provides the foundation for self-correcting institutional learning. Policy can finally be reviewed and legislative action taken based on documented evidence of what ensures child stability. The goal of outcome tracking is not to punish judges or litigate past grievances. If a flawed design produces predictable harm, a different design will produce a different outcome. The only path forward is to install the missing feedback loop, measure what matters, and explicitly re-engineer the system.